Hi, everybody. Karen Tereposky from Samfiru Tumarkin with you today to answer any questions that you might have about employment law. Sorry, I'm just going to get myself a little more light here. I'm looking pretty dark. So good. Hopefully we have a few people with some questions today. And as we go through those questions, I'll hope to give you some information to help you make some decisions about some employment issues you might be dealing with. Obviously, we're Alberta focused here. I'm in Calgary. I'm in the Calgary office of Samfiru Tumarkin, and I deal with employment law as opposed to our other side, our disability practice. While we're waiting for some questions to come in, I have a, oh my goodness, sorry, I don't know what I just did there, technical difficulties. Sorry, 1 minute, bear with me. Here we go. Sorry, I was locked out of my computer there for a minute. Something fell on my keyboard and locked me out. So apologies for that. So while we're waiting, just wanted to highlight a blog that I just did. It's been put up online now relating to a pretty big merger that we have going on coming up pretty soon, set to close in May between Whitecap Resources and Barron, which used to be Crescent Point Energy. So it's a pretty big deal. It's going to be a huge, huge company after that deal closes. And, there's a lot of employees involved who may have some questions about what their rights are going to be, after that merger. So I did put a blog up online on it, and it's, it deals with a lot of things that, employees of companies that are in a situation where companies merge or one company takes over another company might have to deal with. One of those is, if you are terminated after that transaction, which does happen. Companies sort of reorganize and they kind of clean house sometimes. So a lot of times employees have considerations about, are they going to get severance if their job ends after the merger? And that's something to, it's an obvious worry. But if that happens, you're still entitled to your full severance. In Alberta, under the Employment Standards Code, there is a provision that deems your employment to continue. So, don't worry. You shouldn't be able to be just, completely fired based on being on probation or something because it's a new company. That service should continue, and you should be entitled to full severance if that's your situation. I see we do have a question that has come in from YouTube. I have proof I was rejected from getting rehired because I didn't have the skin color they wanted. What is the criteria to prove I'm more qualified for the position or human rights violation? I mean, if you have proof that that was the reason or even part of the reason, that is a human rights violation on its own. I don't think you have to prove that you're more qualified for the position. If there is a adverse effect in employment, and that includes hiring practices based on an enumerated ground under the Human Rights Act, and obviously one of those is race or place of origin. If you can establish that even a part of the reason, doesn't have to be the whole reason, but if it factored into that decision, then that is a human rights violation, and you can be entitled to damages both for just the violation itself. So there's that head of damages just has to do with sort of a violation of the act, and those are called general damages. There's that potential liability on the part of the company, and then there's also liability for lost wages if you can establish that had this not been a factor, that you would have got the job. So that may be on that head of damages, maybe where you were more qualified might come in. But there's possibility for human rights to make pretty broad awards in that circumstance. So I suggest that you either talk to one of us at Samfiru Tumarkin about how to file that human rights complaint, and go from there to see if you can get some of those damages. I have another question coming in. My wife was let go right before going on parental leave. What do we do to deal with this? Is it discrimination? Again, another human rights situation, and it may be discrimination. So again, under human rights, one of the protected grounds is family status, one is gender. So pregnancy, parental leave, family situation is something that's protected under human rights legislation. And if somebody was let go because of that, then there is potential to make a human rights complaint and get that same relief that I spoke about on the last question. It doesn't necessarily mean just because there was a termination right before leave that those factors factored into it. I mean, I'm sure that it seems that way, and it may be that the Human Rights Commission makes an inference that it did. But what the company can do is try to establish that there were other reasons, downsizing or whatever, and that the parental leave didn't have anything to do with it. So that would be their defense in this situation. But definitely worth exploring with human rights. And again, all of our lawyers that do employment law are also well-versed in human rights issues, and we can help you out with that if that's something you'd like to get further guidance on. So I have another question. Wants to ask if his employer asks him to acknowledge a termination policy change. Does this override the employment agreement? If the policy limits severance, do I have to sign or acknowledge? So if you don't have any sort of employment terms right now that limit your common law severance, so basically right now, if you're terminated, you're entitled to common law severance, and your employer wants you to sign off on a termination policy or on a new employment agreement that would limit that, I would take the position that is a major change to the terms of your employment, because that can significantly disentitle you to very large amounts on termination. You don't have to sign these things that make these major changes. The truth of the matter is, if you don't sign it, you may put yourself in a position where they will want to terminate your employment for not agreeing. But if they do that, at this point, you're entitled to common law severance, and that wouldn't be a for-cause termination. That would be a situation where, if they did terminate because you didn't sign, then they'd have to severance you out. If you do agree to it, and if it is properly presented to you, basically in exchange for some benefit. So if, they give you a bonus for signing it, or it's in conjunction with a raise, it would be binding. And, you could be limiting your entitlements on termination. They can do that if they've properly done the contract, they give you some benefit in conjunction with it. And if the language itself is actually enforceable. So there are lots of reasons why language in termination clauses are not enforceable, and we deal with those all the time. That's a good part of my practice is, reviewing termination clauses and looking for reasons why we can make an argument that they aren't enforceable. And there are a lot of reasons. There's very few termination clauses that I do come across that I look at it and think this is definitely enforceable. There's no reason to say that it's not illegal, or it's not vague, or it's not ambiguous. So there may be some reason that we could push back on that termination language if you were terminated later after agreeing to it. But, don't agree to it, basically. Because you don't have to, and it will be a major change to your terms of employment if you do not have any terms limiting severance entitlements right now. Another question from John. My company is being bought from another company as a merger to an existing company. I have been working here for 15 years. Do they have to pay my severance only if they lay me off? Likely, depending on how that transaction is structured, they're not going to pay severance unless it's part of the agreement. So sometimes when companies do a transaction, a merger, amalgamation, or whatever, part of the transaction, part of the deal between the companies will be that the first employer will satisfy all those severance obligations prior to the new company taking them on. I would say that that's not usual, but it does happen sometimes. So only if there is an actual termination of your employment by the first company and then a rehire by the new company would they would the old company be responsible for paying termination entitlements at this time? And that's only if they terminate. So yes, if it's just a straight transition into the new company, the combined company, or the newly purchased company, then you're not entitled to severance unless you're actually terminated from your job. So laid off is kind of the colloquial way to refer to that. But if they terminate your employment, that's when you have an entitlement to severance, unless you have some sort of change of control clause in an employment contract. There wouldn't be a trigger for an entitlement to severance unless they actually lay you off in this situation or terminate your employment. So I have another question. My employer has been making small changes to my job over the last few months, taking away responsibilities and changing commission structures. How much are they allowed to change things? So, I mean, it's one of these definitions under the law that's not very specific, and it's quite subjective in interpretation. So employers are not allowed to make unilateral material changes to the terms of your employment. So those can be cumulative changes, though. So even if they're making little changes along the way, and each of those on their own may not be material, it could get to a point where the amount of changes that they have made in sum total amounts to a material change to the terms of your employment. What I would suggest is making sure you are documenting everything when the changes occur, how they're doing it. If they're all unilateral, you could get to a point where the sum total of all these changes amounts to a material change of the terms of my contract, and then you're in a position where you could resign and claim that you have been constructively dismissed. So basically a resignation based on a constructive dismissal. It is technical how you do that. I would suggest that you talk to somebody at our firm in order to figure out kind of the language to use when you are resigning from your position, if you choose to do that, rather than just do it on your own. Because if you simply resign, it can hurt your chances to claim a constructive dismissal later on. So the one thing to also keep in mind too is with constructive dismissal, there's a defense to it of condonation. So if you're condoning all these changes along the way, you may give up your right to claim constructive dismissal later on. My advice would be to make sure you aren't condoning them. So argue with them, kind of thing. Like, you don't necessarily have to argue, but say, I don't agree with this change, or, I think this change is unilateral. I don't agree with it. Just a quick note to say that you're not agreeing with those changes. So be careful of condoning the changes. And like I said, the how much is not a very objective standard. It's whether it's a material change to the terms of your employment contract. So you'll have to sort of look at it and decide whether these are material changes. Okay, then we have another question from YouTube. What are some of the things I should be aware of as an aging worker in a stressful environment? Well, that's a very, very general question. I guess to be aware of your rights, if you are experiencing any adverse effects in your employment due to age, such as, I've had the situation where it's a stressful environment and an employer has said to an employee, hey, this is too stressful for you because you're getting older. That is age discrimination. So if there are comments like that, you need to document them. You could potentially get to a point where, you want to make a human rights complaint based on some of these comments or some of these adverse effects in your employment. Be aware that under human rights legislation, you only have 1 year to make a complaint from the date that the discrimination occurred. So you can't sit on this for, 2 years while various complaints are mounting. So you lose your right to address a potential situation of discrimination if you don't go to the Human Rights Commission within a year. So, that's something to be aware of. There's definitely lots of situations where aging workers are being pushed to retire. And, that's something to keep in mind, that they can't make you do that. And, if they're trying to, that can be an age discrimination. As far as stressful environment, if, it is becoming too much, there are lots of medical leaves that you could consider if, you're able to get kind of authorization or support from your medical team. There's a job protected leave under the Employment Standards Code that you could access if the stressful environment is becoming too much and you just need to take some time away from work on the advice of your doctor. And it is 16 weeks per calendar year. You just have to submit a note to your employer with just saying your doctor says you have to take off work for medical reasons and an expected date of return, and you would trigger that leave, you would engage it. So hopefully that answers that question. I mean, I could probably go on for hours about what some of the things you should be aware of are, but I think those are kind of the major ones that question sparks in my mind. There's another question, looks like it's from Gregory. My partner was let go from his position of 7 years. They stated there were multiple reasons for the decision, but never anything concrete. Never had any problems before. Is he not owed severance? I mean, probably. It's difficult to analyze that without knowing the reasons for the decision. Sometimes if there are multiple reasons, they can amount to just cause for termination, which disentitles an employee to severance. But generally, in order to be able to justify a just cause for dismissal, there has to have been, in the case of, performance concerns, there has to be performance management. So, there would have had to have been sort of a series of steps taken, like maybe a verbal warning and then a written warning, and then, a warning that says, you have to improve these things within this number of weeks. And if you don't, then you may lose your job for cause. That kind of situation. Or some things are considered, to be kind of instant reasons that just cause can be alleged. They're like the worst case scenarios, like theft, sometimes violence, fraud, things like that are reasons that an employer can say, well, this equates to just cause for termination. I would say 7 years, multiple reasons for the decision, but nothing concrete. It doesn't sound like a just cause termination based on that. But, I would, advise you to get somebody to look at that letter, look at the situation. And there is definitely a possibility that just cause allegation would not be able to be proven by the employer, in which case, the employee would be entitled to full severance, because if you can't prove just cause, then it just becomes a without cause termination. And then that means the employee is entitled to full severance, a full payout of their termination entitlements. And keep in mind, it is the employer's obligation to prove that there was just cause. So the employee doesn't have to prove that there wasn't just cause. The employer has to establish that there was just cause for termination. With regard to the 7 years piece, keep in mind that there's a proportionality test when it comes to just cause. So employers have to say, well, this is a 7-year employee. They've never had prior discipline. Here's what the misconduct is. Now we have to balance it, and we have to think about, is a just cause termination appropriate and proportional to the misconduct in all the circumstances, including all those years of service. So it is difficult to prove just cause. I can't really, make an ultimate determination based on the information that's, in this short little question. But, I think there's definitely a lot to investigate there, and I would say, it's worth looking into with a lawyer from our firm. So I have another one from Reddit from Courtney. Is it considered soliciting if I reach out to a competitor if an employer has laid me off? I would say reaching out to a competitor would be soliciting. That's sort of the definition is, if you take positive steps to actually, solicit business from them. I guess it would depend why you're reaching out. If you're just reaching out, for a reason that you're not prohibited to, then maybe it's not soliciting. I assume that you would have a non-solicitation clause in a prior employment agreement, which is why you're asking. But generally, if you have those terms, those survive termination. So the fact that you've been laid off shouldn't really have an effect on it. If there is, and I'm assuming there's a non-solicitation provision in an employment contract. A lot of times, though, I would say, those non-solicitation provisions are, subject to interpretation. There's a lot of language in there. You may want to get somebody to look at that and give you some advice based on the language and on that particular situation, because obviously what I'm telling you is really, really general, and that's about the best I can do based on, one sentence of information. But hopefully that's somewhat helpful. Then I have another question from YouTube. I've been with the same company for the last 5 years, and I was just laid off. They offered me the legal minimum of 5 weeks, but a friend said I should be getting a lot more. How accurate is that? And should I try to get more? I haven't signed anything yet. So one good way to figure out how much you could be entitled to under the common law is to take a look at our Pocket Employment Lawyer, which is a severance pay calculator. It is on our website, and you can go in there, and what you do is you type in your years of service, your age, your level of position, and it'll ask you some other questions, and it will give you a number, which will be sort of what you could potentially expect a court to award you if you pursued it. The 5 weeks under the Employment Standards Code is a minimum. That is the minimum amount by statute that an employer would be required to pay in your situation. Interestingly, if you're there 5 weeks, your statutory minimum is actually 4 weeks, or sorry, if you're there 5 years, it's 4 weeks under Alberta Employment Standards Law. If you're there 6 years, 6 to 8 years, it's 5 weeks. So not sure what happened there, but as far as, the entitlement to common law notice, unless you have some sort of termination provision in an employment contract, in a policy that you've agreed to, that has been properly implemented by way of, a benefit provided to you in exchange for you agreeing to it, and that language in that document being enforceable. And as I mentioned before, there are lots of reasons why often termination language is not enforceable. So unless, you've agreed to some reason, or you've agreed to some contract that limits your termination entitlements to the employment standards minimum or to 5 weeks. And if that contract is actually enforceable and the termination language is also enforceable, being that it's not vague or ambiguous and it's not illegal in any way, then maybe you're only entitled to employment standards minimums. But, that's a lot of maybes. I would say that you likely are entitled to more than that, and reach out to our intake team. They will assess your situation for you as well, and they can point you in the direction of an employment lawyer that can look to try to get you more potential severance. It's interesting that you said I haven't signed anything yet. If they are asking you to sign something, they really can't get you to sign a release document unless they are offering you more than what you're entitled to under the Employment Standards Code. So if they are asking you to sign something, I'd say that's another reason to reach out to a lawyer and talk to somebody, because that isn't right. They can't ask you for a release if they're only paying you employment standards minimums. So another question coming in from YouTube. If you are a contract worker under annual review, do you have any sort of entitlements if you're not renewed at the end of the contract? We have always been told there's nothing owed if not renewed. So it depends. So if you're getting contracts one after the other and they're automatically being renewed and there's really no negotiation, a lot of times a court looks at that and says, you know what, this isn't actually a fixed term contract situation. This is an indefinite relationship. And they will take all those contracts and they will push them all together and they will consider that entire term of service. So that's one of the factors I think that needs to be considered. You're saying you're a contract worker. Some people think they're a contractor, but they're not necessarily contractors. There's a legal test for employee versus contractor. And just because an employer calls someone a contractor, there are many, many situations where you're not actually a contractor. And there's a lot of factors that go into that have to be considered. The main test, I would say, for employee versus contractor is well, not I would say is what the courts say. It's whose business is it? So are you in business for yourself, or are you really working on behalf of that company? Because if you're in business for yourself, then you're probably a contractor. So if you really have your own business and you're working for, other people, and you have this contractor business and you're holding yourself out in the name of your own name, you're not really holding yourself out as a worker of the company, then you probably are a contractor. But if you're really you're in business for the company, you're working for them, you're not in business for yourself, you might be an employee. So you might not even be a contractor. As far as renewal at the end of the contract, if you're an employee, definitely entitled to some severance, because you can't contract out of employment standards minimums. If you're a contractor, possibly, as long as there's not an early termination clause or it's a true fixed term contract. So if it truly is a fixed term contract, then it may be a situation where you're not entitled to anything. But like I said, if it's a situation where they're getting renewed and renewed and renewed, I've had several of those where we've made the argument that this isn't really a fixed term, it's a pretend fixed term situation. And so there is entitlement to severance there. So it depends on a lot of things. It depends on the wording of the contract. It depends if you're an employee. It depends if you're a contractor. And if you're a dependent contractor, there's also severance entitlement, which means basically that you're dependent on that one company for a good part of your income, and that you're kind of exclusively working to them, or a high level of exclusivity. So there's a lot of factors that go into the answer to that question, and it may be that there's not, but it depends on the language, the situation of how those contracts are renewed, and whether you truly are a contractor or employee. And there are also some rules about fixed term contracts when it comes to employees under the Employment Standards Code that would have to have been complied with in order to make that contract valid in the case of an employee. So I don't know, lots to unpack there. I think that if it does come down to a termination and you don't receive any severance, please reach out to us and get us to look at that. Our people will take a look and be able to tell you whether or not they think you can get something in terms of severance. Another question coming in from Reddit. This one is from Lily. I got sick on Sunday. Before going to the doctor, I informed my boss of the situation. The doctor advised to stay at home and rest and said I would be back in a few days. I sent the note to my boss and requested info on a sick leave policy and how to use my paid sick days off. She did not provide any helpful or useful information. She messaged this morning saying she thought I would be in, and I reminded her of the doctor's note. Could I be fired for this? So could I be fired for this? Employers fire for all kinds of reasons that they shouldn't. So, it's possible. If they do, then, it's not a legal situation. So, you're in a situation where the employer has a choice as to whether to act legally and to act, prudently, or whether they're going to take a step that they shouldn't. So it's possible that your employer is going to get to the point where they just go, yeah, you're fired. But is that legal? No. If you are on a directed medical leave with a doctor's note, especially if it's a doctor's note that has a end date in it, like, so it says, I need to be, so Lily needs to be away from work for medical reasons until date, that triggers a job protected leave under the Employment Standards Code. And that leave can be up to 16 weeks per calendar year. So if you have submitted a medical note with a return date and you are on that medical leave, you are protected under employment standards. Now, does your employer know that? And will your employer abide by that? I can't tell you for sure. But if they do not, if they do fire you during the term of that note, then please reach out. That is a violation of the Employment Standards Code. There's could potentially, depending on what you're sick with, if it would be something that's considered a disability, then it's possible that they would also be in violation of human rights legislation. So disabilities are generally something that are not sort of short term. But, if it's a mental health situation, if there's some anxiety, if there's diagnosis, or some other illness that is, I do some presentations to the Wellspring Society, which deals with cancer patients who are going on leave. So something like that, if that's a reason why, people are taking a leave, that's considered disability. So yeah, I mean, that's not something I would say your employer can legally do, but I also can't guarantee they will act legally. So, can you be fired for it? Not legally, especially if you're within the term of that doctor's note, but it does happen. I had an employee a while ago who submitted her doctor's note and was to be off, and they fired her and said she'd abandoned her job because she didn't come in. And it took us some time, but we did get her compensation for that. So hopefully I've answered everybody's questions today, and I guess it is 1:30, so time to wrap up. And thanks to everyone for giving us your questions, and hopefully there's some good information out there. We have another employment law Q&A tomorrow at 1 p.m. With Lior Samfiru, our founding partner on the employment law side. So tune into that. He's usually got some good insight. Thanks, everybody.